Good afternoon, Troy Wirth on Wirth Radio. Today we are joined with content expert Craig Redler of the Jeffrey M. Verdon Law Group, and we're here to talk about a topic that can sometimes be elusive, and it's really just about basic estate planning. And I think really there's the idea is you've got to walk before you run. There are plenty of advanced planning techniques that can be used, but basic estate planning is a really important part of every person's plan. So with that, good afternoon, Craig. How are you doing?
I'm good, Troy. Thanks for having me.
So a lot of times we meet with clients of any net worth, sometimes a higher net worth, and it's surprising to me how many people don't really have their basic estate planning in order. And that's really what I want to focus on today and why it's really important. So if you could maybe just kind of give in your own words, just what are the basics of estate planning? Why should someone have it? Living versus dying.
Sure. God, most people are fairly in tune with, all right, I want to make sure that this property goes to my son and that property goes to my daughter. And a lot of people think that's what estate planning is all about. A lot of people think if you have a will, you don't have to deal with probate. You hear all these horror stories, probate, avoid probate, avoid probate. And avoiding probate is actually an excellent motivation for doing estate planning, and making sure that this property goes to your son and that property goes to your daughter is also an excellent motivation for estate planning. But it's so much more than that. You hear about probate, everyone wants to avoid probate, and everybody knows that probate's a thing after you die. Just two things to keep in mind. One, merely having a will does not keep your family out of probate if something happens to you. And B, probate in a more enhanced form takes place if you're alive and disabled and haven't taken steps, not only after you die. So to avoid living probate, you want to do estate planning while you're alive as well.
So let's talk about that for a minute. I think where I get hung up a lot of times with clients, we'll sit down and immediately sort of the talk goes to, when we talk about estate planning, it's like, oh, what happens if I die? But really, in my mind, those things can kind of get sorted out after you're gone. But what's really, I think, more important is what happens to the person if they live. And the example that I give, just because it rhymes, is what if you're in a coma in Tacoma? If you are out of state, or if you're in a hospital and you don't have any estate planning, the basic documents that are done, somebody might not have access to your medical records. They might not be able to write checks on your behalf and basically advocate for you. So maybe for a minute, just talk about what is the basic package of documents. If you could kind of briefly just go through, what are the basic documents that you would put together for an estate plan, and the living and sort of living and dying piece of each of those documents.
Sure. Basic estate plan is typically going to consist of a revocable living trust that most people are familiar with. We talk about a trust versus a will, but with a trust-centered package, you're still going to want a form of will called a pour-over will, which is kind of a shortened form of will than we're most used to. The powers of attorney that we touched on a little bit earlier already, the power of attorney where you're going to delegate someone to make financial decisions for you if you can't make them for yourself. And then healthcare powers of attorney and what's called a living will. And the healthcare powers of attorney is where you delegate someone to make medically related decisions for you in the event you can't do it for yourself. And a living will is when it's colloquially called the unplug me document, if you don't want to be kept alive artificially, if you would die naturally. So you definitely want to make sure that any care provider knows what you want, because if they don't, they're going to, obviously that's a mistake that can't be undone. So they're going to err on the side of caution and keep you alive as long as they can, whether that's what you want or not, or whether you have any realistic chance of recovering or any kind of quality of life after a catastrophic event.
Okay. So really, again, that the focus on, if you're in a coma in Tacoma, there's you mentioned those living things, and I think we'll get to the death part of it, which I think there's so much focus on it. But You've got a power of attorney, so somebody can write checks on your behalf if it's a protracted point where you can't do things, right? So if any of those assets that you have that are titled in your own name, the power of attorney would come into play. The medical directive is where you're delegating the authority of someone to sort of act on your behalf based upon what your wishes are, right? And the living will, hopefully you don't get to that point, but certainly those documents need to be in play. I think that's the area that you really can't be overemphasized, is that these are really living. It's while you're alive. It's almost a quality of life to make sure that you're okay.
100%. People think, all right, when I die, I want this to happen, I want this to happen, I want that to happen. But what happens if you're in a prolonged coma? If you're in a prolonged state where you can't express your warning or your desires, or you can't sign a check? Who's going to pay your mortgage? It really comes down to that. People don't think about this stuff. Only one who can write a check on your checking account is you, unless you make provisions otherwise. If you're married, typically your spouse can carry on business, one the surviving or healthy spouse. But really, this comes down to, God forbid, families, car accident, one spouse is killed, the other one's in a coma, or they're both in a coma, or if you're single, these issues come up. And yes, if you, God forbid, ever get into one of those, into a state where you can't take care of these things on your own, your business will carry on, but at huge expense, huge headache to the family, and what you want to see happen may ultimately not be what happens. So you may come around and wake up and not like what had happened.
Right. So so then kind of shifting gears, because what does a trust control, right? A power of attorney basically is saying, here's a chain of command. If I'm in control, so I get to do everything. But if I can't make those decisions, but sometimes I think people don't do these documents because they can't even wrap their head around the idea that they could be incapacitated and somebody else would have to make those decisions, because usually we have sort of a hand of control over ourselves. But so the power of attorney allows to delegate assets that I would control personally. How does the trust work? What is a trust control? And obviously, does that have chain of command in it as well? How does that work? Because you mentioned it was a revocable living trust. So how does that work?
And power of attorney is only going to work as to assets outside of the trust. So if you don't have a trust, you definitely need a power of attorney. Even if you do have a trust, you're going to want a power of attorney for things that are outside of the trust. So it's a good segue into that. For a trust to control anything, it must own the property that you're asking the trustee to control. So by way of a brief illustration, I talked about a checking account earlier. Who can write checks? Who can sign checks on your checking account? Well, you and maybe your spouse if you're married. If you take that same checking account and take it out of your own name personally and retitle it to the name of, the Troy Wirth Revocable Living Trust, well, who can write and sign checks now? It's going to be the trustee of that trust. So when you first set up the trust, you're going to make yourself the trustee. So nothing's going to change. You don't even have to have new checks reprinted. It's you sign your checks now. You form a trust and you move the checking account into the trust. Now the trustee can sign checks, and that trustee is you. So the difference is what you do with the trust is you say, I'm the trustee of that trust so long as I'm alive and healthy. And the minute I can't do it any longer, you name whoever it is you want to step into your shoes. Maybe it's your oldest child, whoever it is. Maybe it's your brother, somebody you trust to do it. So now who can sign those checks? The trustee, whoever that trustee is. You're the trustee while you're healthy and alive. The second you either are unable to do it or when you pass away, now the person that can sign those checks is the successor trustee that you've named. And you can leave specific instructions for that person in your trust. That person steps right in without the intervention of a court, without any kind of interference, without any kind of delay.
So that obviously is one of the most important pieces of it. Then, that I think would that be true in your opinion, because you don't have to involve the courts and you actually have basically pre-made that decision?
Absolutely.
How does
contract that.
I was going to say, yeah, go ahead. I cut you off there. How is that contrasted from another scenario where you haven't pre-made those decisions?
I've got a checking account, and now I am disabled and I can't write checks on my own checking account. What happens? So let's say hypothetically, my son or daughter walks into where I bank and say, "Hey, bank, my dad is over in Tacoma in a coma, in a hospital, and cannot make these decisions for himself, or we need some money to pay his mortgage or pay his medical bills." Uh, the bank's going to say, "Well, I don't know who you are. I'm not just going to give you access to Craig's account. I don't know you. I don't know if this is how he'd want it. I don't trust that you're going to do what he'd want." So come back when you've got some authority. So how do you get authority? You've got to go through, even why a person's alive, what essentially amounts to a probate process, where you get appointed conservator. And I can run through the steps, but without spending too much time on it, it's a very long, protracted, expensive process. It could be a month or more before a conservator is appointed. In that time, things are just on hold. And then once you get appointed, it's not like, okay, here's your paper, go do what you want. Now that conservator can only operate under court supervision. So every time the conservator wants to do anything, they've got to go back to the court and get explicit permission. "Hey, judge, I need to pay the mortgage. Can I do that? Hey, judge, I need to make the car payment. Hey, judge, I need to pay the guy to cut the lawn. Can I do that?" And you've got to get those permissions at every step. So you can see where A, it's hard, and B, it's slow, and C, it's expensive. So I would think that all of those, hard, slow, and expensive doesn't interest most people. So they would want to take appropriate steps to make sure their family never has to deal with that.
Sure. So and of course, you also mentioned the word revocable. So this obviously is changeable. Is there any kind of protocol for how often? I mean, obviously, if you draft documents and you create enough flexibility in the documents, maybe they don't need to be changed, but obviously the word revocable is in there.
It depends on your estate. If you just have a basic, you're not looking at estate tax consequence, and you just want to say, all right, when I die, I want the gun collection to go to my son and the jewelry to go to my daughter, and have them split everything else. You may not have to change it. I'm going to be the trustee while I'm alive, and the second I'm no longer the trustee, then my oldest child's going to be the trustee. You may not have to change it, but fact is, like you mentioned, you can. Things do change. Maybe your estate grows and now it's a taxable estate. Maybe you named your son, and your son gets married now to your daughter-in-law that you don't like, and you're afraid that she's going to influence him in a negative way. All right, my son's no longer the successor trustee, my daughter is. So but revocable living trust gives you maximum flexibility. Yes, you can always go back and put specific instructions and restrictions. All right, son, while you're the successor trustee, you can spend money on me and maybe give some money to this charity. Okay, I don't like that charity anymore. Maybe you can spend some money on me and don't give any money to that charity, but you can give money to this other charity. So yeah, you can customize it as you go, or
Okay. So let's shift gears and talk a little bit about the probate process itself. I think because what is the probate process? I mean, what's the definition of probate?
Probate, it comes from the Latin word to prove, and it basically comes from the concept. It's the state's way of making sure that only those entitled to take from an estate do, and those that aren't entitled don't. And it's the state's way of making sure that everybody's treated fairly. So going back again to that checking account example that I keep going back to, because it's a very basic example that most people can relate to. What the state's trying to avoid through the probate process is a rush to take assets improperly. So if I die tomorrow, I don't want my son and my daughter racing each other to the bank to see who can get at my money first. So the probate process is the way the state says, slow down, everyone. We're going to make sure that the son gets the guns and the daughter gets the jury, and they split everything else, and it's not who can run off with it the quickest, which conceptually is good. That's what we all want. We don't want a race to the bank to see who can grab the money first as soon as we die. Having said that, there are other techniques and other ways that you can make sure that that doesn't happen, and then avoid some of the headaches that go with probate. And there are many.
So the probate process itself is not in and of itself as bad. It's just that it's time consuming. And so it sounds like the trust is a more efficient way to do that. Are you saying that the trust
Without a doubt,
avoids the probate process?
Couldn't have put it better. I mean, and just real briefly, let me run through it, and you can see what a headache it potentially could be. So again, you've got assets. The court has no idea what assets you own. The court has no idea who it is you want to give them to. The court has no idea that the person you've named as your executors, is typically the term we use, is going to do the job properly. So what has to happen when someone dies, you have to go to a court and first ask to be appointed executor. You have to prove that a person's actually died. You have to prove the genuineness of a will, or if there's not a will, you're going to follow the intestacy statutes. The state's going to set out where your property goes. Then the state's going to want an inventory of the entire estate. Then the court's going to want a bond covering the value of the estate to make sure that if the executor steals, that the other beneficiaries have some kind of recourse. Then the court's going to want a appraisal of the more expensive assets. The court needs to know the value of say, a house, or things that aren't immediately, where the value isn't immediately obvious, like a bank account. Court's going to want to make sure all the creditors get paid. The court's going to want to make sure that anybody that's even a potential beneficiary is notified and has an opportunity to come in and speak if they want. And going back to what I said about being conservative, even after death, before you can spend any money as the executor, you got to get court's permission. Hey, court, there are some outstanding medical bills. Can I pay this? Hey, court, there's an outstanding MasterCard or Visa bill. Can I pay that? And you got to go through all these steps, and there's waiting periods again for creditors to make their claims. And at the end of it all, you got to do a full reconciliation. Hey, judge, remember when we started, I gave you the inventory. This is what it was worth. I spent money on this, and this. Oh, you didn't give me permission here. I might have a little trouble. Let's go back and get some retro permission. And this is what I have left. And here's what I'm going to give to this beneficiary. And here's what I'm going to give to that beneficiary. And it's just a never-ending nightmare. So I probably spent more time on that than you want. But
no, that's fine. No, it's totally
imagine
fine.
that in real time. By the time it's all said and done, you can count on probate to take a year plus and a significant percentage of the value of the estate just for administration costs.
Sure. So another, I think, confusing area that does maybe ultimately tie into more advanced planning, but do you by virtue of having a revocable trust and doing this whole sort of basket of basic estate planning, do you, at that point that the ink's dry and the stuff's notarized, do you get creditor protection through this?
No, not with a basic package. You mentioned the revocability, and that's sort of the key.
Because a lot of people, when we sit down with people, a lot of times when they do have a trust, there's a lot of misconstrued ideas. If, for a lot of people, they don't have it and they need it. This basic set of documents for all the reasons that I think we're discussing here. But just to be clear, do you get creditor protection? And I mean, obviously there's, so I'll just, answer that one. Creditor protection for
the short answer is no. And again, going back to the concept of revocability that you mentioned, that's sort of the cost of revocability, the cost of all that flexibility. The way the law looks at it is if you control your assets 100%, then they're available for satisfaction of creditor claims. Which again, they're more advanced planning. We do some forms of irrevocable trusts that give you really, really good creditor protection. And that scares people because I'm saying, all right, well, does that mean it's irrevocable? I can't change it and I don't control my assets? Well, little secret is the way we write these things, you actually do have a ton of flexibility and a ton of control, but different discussion, different day. But
Sure.
the short answer to your question is no. Basic estate planning gives you zero in the way of creditor protection.
Yeah. And I think that's a good point, because at the end of the day, when we talk about basic estate planning, it's not necessarily, I mean, you've got to take these things in layers a little bit, peeling back the layers of the onion. I mean, I think the first thing is just for folks to have knowledge of the need to take care of themselves through these legal documents so that they're not at the winds of fate through anything that could happen because they don't have this basic planning in place. Um, and then avoiding the probate really is more so, I mean, there's a living piece of it, but there's also a death piece of it, that your estate's in order. And then beyond that, obviously that does go into some other more advanced planning strategies for
Great.
for creditor protection.
Fantastic point. Look, we're all going to die. And when you die, if you don't have this done, or if, God forbid, you find yourself in a coma or disabled somehow, if you don't have this stuff done, life goes on. The sun's going to rise tomorrow and the state is going to make things happen. It's just a question of A, you leave it into the state's hands. Are they going to do what you would have done if you could make the decision for yourself? And B, how much headache are you loading down on your beneficiaries, your kids or your family, or whoever it is that has to conduct your business in the event you can't?
Sure.
And how much money you're going to waste on this stuff that you don't have to. So those are the factors. But yeah, look, this stuff has to get done. So it's just a question of how much of a headache is it going to be.
So if for someone, for our listeners, if they might have an existing estate plan and they know that there's already amendments that need to be made because of beneficiaries passing, or any of a number of different reasons, or they don't have any documents in place, how would they work with you? How does your firm work to help someone get through that process?
We would typically review any existing documents and first talk to the client and find out exactly what it is he or she understands that they do versus what it is exactly that they want. And we can always verify, all right, you told me you want X and you think these documents do X. Well, they don't. And here's what we need to do to them to get you what you want. Or have you considered some of the things? And again, our job as attorneys is to think of the things that our clients don't necessarily think about on their own. Okay, well, you've created a little tax bomb here for yourself. Maybe we can fix this so it doesn't get you into trouble. Or you've got a tax obligation that can be mitigated if we add this document to your overall package. So, and I would say this to anybody, have your plans reviewed. These are not one-offs and forget about it. Doesn't matter who did it or have them reviewed every 7 or 10 years max, just to make sure as the laws change, as your life changes, as your beneficiaries change, that they still do what you think they're going to do.
Yeah, that's a really good point. You talked about the laws changing. I know the laws seem to change all the time, and it seems like it would be prudent to go through that process just to take a look at them. So is that part of what you would do, as well as either obviously sit down and have a consultation, but also reviewing existing documents?
Absolutely, 100%. And the other thing I would consider that I forgot to mention is some of the documents, now the basic trust or will, they typically don't change a ton if there aren't any major changes in your life or if you don't have a taxable estate. But the powers of attorney, not only do those laws change, they just get stale. I mean, banks and financial institutions are not thrilled or happy about relying on a power of attorney that's 25 years old. They just don't want to do it. So it's just a good idea to make sure that they don't get too stale, and just to update that aspect of your estate plan is fairly easy and fairly inexpensive.
Well, that's an important point, because I have heard that before. Maybe you could just mention that for a minute. I have heard where, the way that you just described that is like, okay, a bank, your beneficiaries walk in, you know, in a scenario, whatever it is, a power of attorney that's old, um, and it's their legal department. Do I understand that right? It's almost at their discretion as to whether or not they might say, well, this thing was drafted in 1986. Like, we're questioning whether or not you're still the right person. So if they really are in this moment of, gosh, we want to be held harmless from this, they may say, you know what, we're going to defer on that. We do want the court to render an opinion. Whereas, is that what you're saying too? Is if the document was maybe 3 years old, then, you know, that's a lot more fresh than 25 years. Is that kind of where you're going with that?
Exactly. And
And
that's
have you
100%.
seen it? And have you seen that?
That's exactly spot on. Yeah, I've seen it. I've really never, honestly, never had a bank come back and say straight up, we're not taking these, but I've just seen them cause headaches, and it's just caused a whole lot of headaches that just didn't need to be. So we would always get it done for our clients, but it again, it's just a
It's
headache
extra
you can afford.
negotiating and extra sort of headache and uncertainty. And at a time when your beneficiaries and the trustees probably want to have, it's already I mean, speaking from experience, when someone passes away, it's always a real bummer, because you're trying to grieve and then you're trying to deal with all this administration. So I would think you'd try to every extent possible mitigate those.
It's another huge factor, and which we didn't mention, and I'm glad you brought that up. You know, your beneficiaries, your kids, your friends, your family, they've got enough on their mind that they don't need to be running off to court and arguing with banks. 1,000%.
So I think that's the upshot from this episode is, you know, either review your documents or create them if you haven't done so for your own benefit, much less obviously secondly those that you love. But I think it always comes back to this not that I ever want to take a vacation and be in a coma in Tacoma, but you know, the idea of making sure that everything's okay, if something happens, that there are mechanisms in place so that my well-being is taken care of first and foremost.
Yeah, we just came through an election, and there's the political left, political right. And the one thing I think everybody agrees on is we don't need the government making decisions for ourselves or for us. And if you don't make a decision for yourself, the government's going to, the state will.
And it can be a big hassle for our beneficiaries along the way, and for the people that we love, and that are trying to take care of us and do the best for us. So, well, I want to thank you for taking the time today to kind of walk through the basics of estate planning and how these documents work. Obviously, we could talk more and more about some of the nuances of these things, but at the end of the day, hopefully this is a primer for a person who's thinking about it, to be a call to action to get in there, see their attorney, or come and see you and review the documents and make sure that they have a plan in place to cover these contingencies.
My pleasure, and anytime.
All right, great. Well, with that, until next time, Troy Wirth on Wirth. Take care.